I would like to convene this meeting of the Lincoln County Board of Commissioners. Good morning. It is Wednesday, June 22nd, 2016. All three commissioners are present, which constitutes a quorum. Our first order of business is adoption of the consent calendar. Consent calendar items are routine in nature or have been discussed at previous meetings. Are there any items that commissioners or staff would like to either remove or highlight?
I'll move for approval of the consent calendar.
Second.
Motion and a second for approval of the consent calendar. All in favor, please say aye.
Aye.
Aye. All right, the consent calendar is approved. Now we move on to a series of public hearings regarding the 2016-17 budget for the county and its special districts. And I will go through the procedure for these hearings. The Lincoln County Budget Committee has already held 5 public meetings, including the Siletz Area Enhanced Law Enforcement Service District around the county on the budget, to receive public comment, and has approved the 2016-17 budgets that have been presented today. For each public hearing, I will open the public hearing. We'll receive an update from the budget officer and staff. We will receive public comment, a maximum of 5 minutes per commenter, to be followed by the board, and motions. So the first item is the 2016-17 Extension Service District Budget Hearing. At this point, I'll open the public hearing and request an update.
Katie Jacobson is here. She is the actual budget officer for the Extension District. But we have made no changes to this budget since it was approved by the Budget Committee. If you have any questions, please address them to Katie.
Any questions from the board? I'll entertain the motion then.
No, you need to ask for public
Oh,
comment.
right, I'm sorry. Thank you. Is there any public comment on the proposed Extension Service District budget? Hearing none, I will now entertain a motion.
I'll move to approve the resolution adopting the 2016-17 budget, making appropriations, levying taxes, and categorizing the levy for the Lincoln County Extension Service District as approved by the Lincoln County Budget Committee, and to authorize a property tax levy at the permanent tax rate of .0451 dollars, or 4.51 cents per thousand, that these taxes be imposed and categorized for the tax year 2016-17 upon the assessed value of all taxable property within the county in accordance with law as of 1 a.m. July 1st, 2016. I also move to authorize signing the certificate of appropriation of funds supporting the extension programs.
Second.
We have a motion and a second for adoption of the Extension Service District budget. All in favor, please say aye.
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 Aye. All righty. Thanks, Katie.
Thank you.
We will now move, we will close that public hearing and open the public hearing on the Solid Waste Disposal District Fund. Staff report.
Well, this budget also has not been changed since the Budget Committee approved it. Mark Salins, the district manager, does not seem to be here this morning, but it's the same budget that the committee approved.
Any comments or questions from commissioners? Hearing none, I'll ask for constituent input on the Solid Waste Disposal Service District budget. Hearing none, I'll close the public hearing and ask for a motion.
I move to approve the resolution adopting the 2016-2017 budget and making appropriations to the Lincoln County Solid Waste Disposal Service District as approved by Lincoln County Budget Committee.
I'll second it.
We have a motion and a second for adoption of the Solid Waste Disposal Service District budget. All in favor, please say aye.
Aye.
Aye. All righty, we will now move on and open the public hearing for the 2016-17 Transportation Service District budget. And report from staff.
This budget has not changed from the time the Budget Committee approved it either. Cinda Bruce is here to answer any specific questions you might have about the Transit District's budget.
Questions from commissioners?
Again, it hasn't changed since it was before the budget committee.
Right. Is there public comment on the proposed Transportation Service District budget?
I have a question.
Okay, could you come forward, please?
Sure.
And identify yourself for the record.
Cynthia George, Toledo, Oregon. I'm very curious, is this transportation, is this just the bus services, or is this also the transporting of patients to the valley for medication? Is that part of the transportation budget?
I think that you're talking about the brokerage transportation, medical brokerage. Yes, that's not provided by Lincoln County Transit, but we do have a Coast to Valley bus that goes over to the valley twice a day.
And does it take the patient, no, it's just the medical transport that does.
We do go to the regional facility just as just to
And are we
provide the
supplementing that transportation for patients? Are we supplementing, Lincoln County, is it supplementing patients to get over to the valley?
Yes.
For medication? Thank you.
Yes, absolutely.
Any other public input? If not, we'll close the public hearing and entertain a motion at this point.
I move to approve the resolution adopting the 2016-17 budget, making appropriations, levying taxes, and categorizing the levy for the Lincoln County Transportation Service District as approved by the Lincoln County Budget Committee, and to authorize a property tax levy at the permanent rate of $0.0971 or 9.74 cents per thousand, and that these taxes be imposed and categorized for the tax year 2016-17 upon the assessed value on all taxable property within the county in accordance with law as of 1 a.m. July 1st, 2016.
Second?
Motion and a second for approval of the Transportation Service District budget. All in favor, please say aye.
Aye.
Aye. All right. Thank you, Cinda.
Thank you.
We'll now open the public hearing for the 2016-17 Animal Services District budget and hear from staff if there are any updates or changes.
Again, this budget has not changed since the Budget Committee approved it. Laura Braxling is here to answer any questions about the animal shelter, and I believe Acting Lieutenant Cameron is here for the other animal services involved.
Any questions from staff? From commissioners? All right, at this point, we will open for public comment on the Animal Services District budget. Hearing none, we'll close the hearing and entertain a motion.
I move to approve the resolution adopting 2016-2017 budget, making appropriations, levying taxes, and categorizing the levy for Lincoln County Animal Service District as approved by the Lincoln County Budget Committee, and to authorize a property tax levy at the permanent tax rate of .11 or 11 cents per thousand, and that these taxes be imposed and categorized for the tax year 2016-2017 upon the assessed value of all taxable, I assume it's property within the county in accordance with the law as of 1 a.m. July 1st, 2016.
I'll second it.
We have a motion and a second for adoption of the Animal Services District budget. All in favor, please say aye.
Aye.
Aye. All righty, thank you. Now we will open the public hearing for the Siletz Area Enhanced Law Enforcement Service District. This is our newest district created by voters in the May election and was the subject of our final budget hearing. Staff report.
This budget has not changed since the Budget Committee approved it on June the 8th.
Questions or comments from commissioners?
I just comment that this is the first budget for the law enforcement district because it was newly created, so.
Correct. Is there any public comment on the Siletz Area Enhanced Law Enforcement Service District budget? Hearing none, I will close the public hearing and entertain a motion.
Move to approve the resolution adopting the 2016-17 budget, making appropriations, levying taxes, and categorizing the levy for the Siletz Area Enhanced Law Enforcement Service District as approved by the Lincoln County Budget Committee, and to authorize a property tax levy at the permanent rate of $1.31 per thousand if these taxes be imposed and categorized for the tax year 2016-17 upon the assessed value on all taxable property within the county in accordance with law as of 1 a.m. July 1st, 2016.
Second.
Motion and a second for approval of the Siletz Area Enhanced Law Enforcement Service District levy. All in favor, please say aye.
Aye.
Aye. All righty, it is approved. Now we will open the public hearing on the 2016-17 Lincoln County budget. And staff report. I know we do have changes on this one.
There are some minor changes to several funds within the county budget. It didn't increase the total amount of the budget, but just shifted some appropriations between contingency and some new revenue that was recognized got included. But overall, it was a shifting of expense rather than an increase to any particular fund. I take that back. The mental health, or the public health and mental health both had a couple new revenue sources that did raise their budget slightly. But other than that, this budget remains pretty close to what the Budget Committee approved.
Comments or questions from commissioners?
Now, again, I think that it's important to note that the Health and Human Services budget has the more significant adjustments. They're not general fund money, and it's really the result of additional revenues being received by the county.
I can't hear him.
I said that the general fund is not being adjusted, that the additional revenues that's being received by the Health and Human Services Department are what are the more significant adjustments, and that is not, again, general fund money.
Primarily state and federal dollars for healthcare and human services.
Correct.
All right, at this point, we will open it up for a public hearing on the county budget.
Good morning, Commissioners. Once
Good
again,
morning.
Cynthia George, and I tried to ask some questions last week on your budget, so I'm glad I made it in this morning. I have some real questions on, number one, your increase in pay. As we all know, Social Security did not get an increase in their standards of living this year, and I'm wondering how you can justify increasing your pay as county commissioners at a time when this county is hurting, number one. I see that you spend quite a bit on legal counsel for the county commissioners. And one of the things I don't understand is in 2013 you had $162,000 in paralegal fees, and it dropped down to $65,000 this year. But you've got budgeted a public information officer of $63,000 and an administrative assistant at $49,000. You've also got contract employee for $22,000. That's all within your, from what I understand, that has nothing to do with the DA, no nothing. This is your county budget, your legal defense. Am I correct? The county, anyway, I'm sure you're not going to answer me, and that's fine. The other thing I raise real issue with is your travel expense. In 2013-2014, you had a $7,400 travel expense. It's now, 2 years later, up to $14,000. Meals and lodging, you went from $3,300 up to, this year, budgeted $6,500. So I see a real professional conferences I see here. Huge increases in that budget also. I also am wondering why the county spends so much on the Association of Oregon Counties fees. You've got another $12,500 this year for the Association of Oregon County fees, but then you've also got a AOC NACO public land assessment that was in 2013 $3,200. It's now up to $8,500 2 years later. So there seems to be some real discrepancies. The other thing is you've got some real revenue issues. I see 2013, 2014, you only had $12,000 in property management revenue. By 2016-17, you got $126,000 revenue. And another big one is the election reimbursement. 2013-14, you had $9,700. And 2016-17, it looks like it's going to go up to $68,000. So, seems to be some real increases in costs and revenue. And I hope you can explain that to the public. Thank you.
Is there any other public input on the budget? Hearing none, I'll close the public hearing and entertain a motion.
I move to approve the resolution adopting the 2016-2017 Lincoln County budget, making appropriations, levying the tax, categorize the levy as approved by the Lincoln County Budget Committee with the changes as submitted by the budget officer at the hearing, and to authorize property tax levy at a permanent tax rate of 2.8202 per thousand for general operations, and that these taxes be imposed and categorized for the tax year 2016-17 upon the assessed value of all taxable property within the county in accordance with the law as of 1 a.m. July 1st, 2016.
I'll second it.
We have a motion and a second for adoption of the budget. All in favor, please say aye.
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 Aye. Thank you, Janice. Alrighty, now we move on to discussion and information items, and I am going to make one change to the discussion and information agenda. I'm going to switch items B and C. We have some scheduling issues, so we're going to take up the Commons update ahead of the vacation rental dwelling discussion. As Kristen, you'll hear, the first item is proposed changes to the Lincoln County fee schedule for the 2016-17 fiscal year.
Good morning, Commissioners. Kristen Yule. We only have 2 departments that are proposing fee changes for the 16-17 calendar year. The first department is our Community Corrections. They're proposing to lower their county work crew fee. The reason being is that they are losing out to a lot of bids and contracts based on how high the fee is set from other local groups that have lower fees. So Ms. Gonzalez, who's the director, wanted me to indicate that they are negotiable depending on the type of job that they're bidding for, but she would propose to lower that fee.
And this is going from a base fee of $550 per day to $450 per day.
That's what she's proposing.
Okay.
And then the next department is our Health and Human Services Department, the Public Health Division. And I have Amy Chapman, our Environmental Health Manager, here to discuss the increases. And she's proposing a 3% increase across the board for those fees.
Okay. Amy?
We're going to request a 3% increase in fees due to cost of living increases in our costs for our budget.
And this still doesn't get us to full cost recovery for the program, does it?
It does not.
Do you have an estimate? Or if not, maybe if you could get back to us roughly what percentage of the cost of providing these inspections is covered by the fees?
I can do that.
Okay, I think that would be of interest, because sometimes people do ask us about this, and I know this is one program that is not fully fee supported.
I think it also should be noted that there was a period of time where these fees weren't increased at all, and so that caused the deficit to be created as far as what our costs are versus what we're charging for those services. So again, this is an effort to try to bring that more in line.
Yeah, that was, I think, a 3-year freeze we put on the fees. And even before that, we weren't at full cost recovery, but
Historically, environmental health has been supported by the county. It started off that way. When I was first employed, it was supported by general fund quite a bit. And there was no increase in fees for years and years and years. And then the sudden change in the department having to support itself.
right.
So if it looks acceptable, I can prepare an order, and this could be an action item at your next Wednesday meeting.
I'm fine with that.
So am I.
right,
Okay,
thank
thank
you.
you. At this point, I'd like to ask Mr. Beisman and Mr. Kenyon to come forward. And this would be, and also Janice, do you have those finance fees available? Did Janice leave? Or is she still here?
No, she left.
Oh, she was going to have figures for us. Well, I guess that can wait till a further meeting on potential. Anyway, we're taking up the discussion of the Lincoln County Commons, follow up to our previous discussion on moving this project forward. And I know Mr. Belmont and I have had conversations with Mr. Beisman and Mr. Kenyon, and we're looking at routes to accelerate the schedule on getting this project moving. And Mr. Belmont, do you want to say anything, or do you want to just turn it over to Mr. Beisman at this point? But basically, we're talking about getting a request for proposal for master planning and architectural services.
I'll let Mr. Beisman talk about what we've been working on in that area. Then I want to talk a little bit about what conversations I've had with the city of Newport, which could also be a potentially large funder of the project. And what we're discussing there is the way to move forward.
Okay, Mr. Beisman.
Very briefly, I'm Jim Beisman, member of the County Fair Board. With me is Roy Kenyon, County Public Works Director. We've talked to the board before. As you know, the increase in the transient room tax passed in May, and we are now proceeding with a couple of different things that we've talked about. One is making the fairgrounds more usable, if you will, for the upcoming fair event, and keeping those grounds in reasonably decent and usable shape until such time as we can make substantial improvements. Fundamentally, those are utility improvements, water, electrical, that type of thing. We are also going to have the buildings painted to dress it up. That's what we're currently working on, with the exception of the painting of the buildings. I think that everything that we're doing so far in the utilities will ultimately be salvageable when we do the new structure out there that is anticipated. Secondly, I'm working with Mr. Belmont on an RFP to select an AE firm, a consultant, to work on the really what will be a final refinement of the master plan and provide AE services for the new structure and any ancillary services that may be needed. We wanted to touch base with you briefly today because the Fair Board will be meeting tomorrow with the idea that we will be moving ahead with these things. So again, I wanted to talk to you today and let you know that. And then Mr. Belmont has a few additional things.
So I have met with the city manager in Newport because, as we've indicated and going along in this process, the city of Newport has committed, potentially committed some funds for the major building on the property, as well as some of the ancillary improvements in that area. This is within the urban renewal project within the North Urban Renewal area, which was recently established. And so we talked about how we can begin those discussions and get some indications of what the city would be looking at in terms of their participation. And it's interesting that what they would like to do, and the first thing we will do is they would, at the next scheduled urban renewal meeting, I'm going to go and make a presentation on where we are. I'll try and see if I can get Mr. Beisman to attend with me to give them an update on where we are and what our next steps are, how we intend to move forward. And then their suggestion was that actually it's very similar to what we're doing with the RFP here, that the steps to move closer to see specifically what they would be able to contribute, both in terms of the costs and what there might be in terms of expectations, is to do a refinement of their urban renewal plan. And that's what they're actually starting to do in a couple of areas. And we discussed the possibility of moving that forward parallel with the process we're doing here on the master plan to do the refinement of urban renewal. And that'll give you a better idea to determine, what kind of participation the city would have in this process, whether that's acceptable to you. You're going to have to review that, see if there's limitations or whatever else you might want to do. But how we can integrate them into this process so that we can move forward. If they're going to be part of this process, we can move forward as soon as possible with that additional funding.
And further regarding funding, I've had conversations with Janice Riesbeck, our finance director, and she is doing investigation to look at the possibility of a revenue bond against both the existing room tax revenue stream that's dedicated to fair facilities, as well as the new money. At our previous discussion, the board discussion, I think the board consensus was a desire to accelerate our timeline for this project, and it seems like the most logical way to get the ready cash to do that would be a revenue bond, and interest rates are still relatively low. The fees historically low, exactly. So I think when we have a little more information from Janice, we can decide if that's a viable option. And again, talking about timeframes, if the BOC and Fair Board are okay with moving ahead with this request for proposal for architectural and planning services, Jim and I talked about a kind of a best case scenario, no unexpected bumps in the road, but perhaps if we have this firm on board by fall, we can complete a plan by early next year, spend next year in doing geotechnical work, site prep work, permitting, lining up a contractor that potentially we might even be ready to begin construction of the new exhibition hall early in 2018. But again, that's just projecting a best case scenario, I think. Comments or questions from the commissioners at this point?
My concern has been that we work with the city of Newport to be a part of the process, and Council Belmont's already indicated that there are parallel processes, and that we want to integrate the city into this process. I think the best result will be a project that has the city of Newport's as a part of the process, and certainly the urban renewal dollars would be a significant part of that success. So I would glad to hear that we've met with the city of Newport, and I'm glad to hear that they're receptive.
Okay. No questions from Commissioner Thompson at this point, so do we have a consensus to move forward with a request for proposal for architectural and engineering services now being developed by Mr. Weisman and in consultation with Mr. Belmont?
I'm okay with that.
Okay, and this will be paid from the Fair Facilities Fund, as was our previous work on this project.
I'm okay with it.
Okay.
Good. Thank you,
gentlemen. Alrighty, at this point, we will get to our discussion of vacation rental dwellings. And I'm going to ask Mr. Belmont to start off with kind of an overview of where we're at, introduce his decision points memo, and a timeline for further steps.
Commissioners, I just would note for the record that we have received some submittals, some written submittals, which are in our record from a variety of parties, which have been made available to you to consider as you're reaching a decision on how to move forward on this particular matter. And what I have prepared for you is based on the discussions we had, the several public meetings we've already had, the discussions that have been before you. What I see as the areas within the draft ordinance that we need to have some direction on what to do so that we can finalize this and move it forward. I would note there's a couple of, some of the materials you got there are a couple of legal arguments made related to the ordinance. I just want to just tell you that I have reviewed those legal arguments. I'm fine with moving forward with this ordinance with all the decision packages we have here. I do not feel that those arguments really hold merit. And we're dealing with the party those arguments on a variety of different issues here, and we'll continue to deal with them on this. So to the extent that that's been raised, I do not see those as an impediment to moving forward. So with that being said, I'm going to go through the list of these. I think there's 7 different touch points that we want to get some direction from you on to incorporate into the ordinance. If you give us a consensus on what you want to do with these, we could move forward as soon as next week with the first reading of an ordinance. And that would be June 29th if you want to do so. If there's more work you want us to do, then we'll do additional work. And I know that in the audience are a number of people who want to comment on the proposal here. And I'm probably going to touch some of the areas in which people want to comment, but you'll have an opportunity to talk about those with the commissioners after I've done my presentation. So we'll just go right into this. The first one was the question of the local contact. And the current version just says that the parties had to provide a contact name, but didn't require it to be a local person. In looking around, especially within Lincoln County, looking at the various licensing schemes that are here, it seems pretty common to have a local contact person. And I was getting that as sort of the direction that you wanted to go, but I need a confirmation of that. And we would actually, if we do that, we'll define what local means in here and what kind of information that local person would provide. And I've given you an example of how that could work in a revised ordinance. The second thing that we wanted to discuss was the manner in which notice or contact is made with surrounding property owners. It was raised during the public hearings that a number of jurisdictions actually get the notice of the contact person, all that kind of information, but don't require the licensee to actually supply that to the surrounding property owners, but actually have the city or a county actually provide that notice. So the county in its application process would gather the information. We have at our disposal the tools to determine, owners within with the assessor's records, owners within a certain distance of that area, and actually mail out the notice ourselves. And I found that that's actually something that's done within a number of jurisdictions. They're actually mailing out these notices themselves. So what we're suggesting to you is that we do that through the licensing process, collect the information and mail it to property owners. That way we can ensure that notice does go out, does supply the information to everybody. A secondary issue with this that was raised is we've proposed 250 feet, property owners within 250 feet of the VRD, and there was some suggestion that maybe that wasn't enough or too much. So we did a little bit of checking out there, and I noted for your purposes here that the City of Lincoln City in their process uses 250 feet also. The City of Newport actually only uses 200 feet. So I think the 250 feet is pretty reasonable. It seems to be sort of a norm out there. So we need some direction on that particular point. Response time for complaints was a major consideration, and what I found is that's all over the map. That really is all over the map in terms of what's being done. Lincoln City has no time frame, but they require, and this is a quote from their proposed business license, that within a timely manner as may be considered reasonable depending on the circumstances. That's the standard they use. Now, we're very used to in code activities dealing with reasonableness and timeliness. That's not something that we can't deal with, so that may be a standard that's very usable and enforceable. The City of Newport is kind of on the opposite end of the spectrum. They only require a response to be made within 24 hours. So it can be quite a long time between the time the initial issue comes up and the time the response is made. So what we're proposing, based on what we had heard at the public meetings, that 20 minutes might be too much, too quick a time to turnaround time, but we need to do something, fairly close to the time that the complaint comes in. So I'm suggesting this additional language here that says the owner or contact person shall contact a renter by phone or in person or otherwise respond within a reasonable period of time, which shall normally be within 1 hour, unless circumstances require a lesser or greater time. Gives us some flexibility to look at the circumstances, see what the nature of the complaint is, what the response is, why it was or wasn't done. But it allows us some flexibility in that, but also sets some standards for it too. And that's upon receiving any complaint from a neighbor, local fire department, or the sheriff's office concerning the conduct of a renter. I think this is a good compromise between what's there, and I think it's something that we can work with pretty good in our process. The next touch point is the garbage service. And what we had provided in the original draft of the ordinance was that there had to be an appropriate level of garbage service, but we allowed for an alternative, that the applicant could come in and talk about alternatives to garbage service. I have had discussions with our franchised haulers about the services they can and do provide currently to VRDs. And they're already doing a lot of work in this particular area. They all can provide what they call custom service, and some of them call them a concierge service or valet service. And that includes either picking up and returning containers on site to actually go behind in a backyard and pick them up and do that or return it. They also have a variety of options for service that could be weekly, monthly, those kinds of things. And if it's a heavy use period, they can pick up upon request, doing those kinds of things. So it sounds like there's a lot of flexibility within the franchise systems in all the areas of the county here. And that we could work, again, if we say an appropriate level of garbage service, well, we can look at each individual situation and determine what that is. And if there's complaints that come in, we can talk about what additional services, for instance, might be done in order to alleviate those particular complaints. So I'm recommending that we delete the alternative language so we can assure that there's some kind of uniform provision of these services there. Probably the biggest issue that's generated the most discussion, especially from VRD owners, but it also from neighbors, is this idea of an occupancy limit. You've gotten materials from others who've been providing you information related to that particular issue. Our current version provides an occupancy limit of 3 persons per sleeping area plus 2, with a maximum limit of 16 persons per dwelling. I've looked at Lincoln City's proposed and talked to their attorney about their proposed code. They're actually in the process of revising their licensing program, and then also looked at Newport and their definitions for these particular activities, and found that it's not unusual to have, at least locally here, to have an occupancy cap doing that. In Lincoln City, although the definition will be 2 persons per bedroom plus 1, they also define, their attorney tells me they define a VRD as having a maximum of 5 bedrooms. So that gives them an effective or de facto cap of 11 persons in a VRD. Newport has the VRD definition is it has a maximum of 5 bedrooms. And they provide 2 persons per bedroom plus an additional 2 people. So that effectively establishes a cap of 12 persons in Newport. I have done some checking in a different arena, and I want to make sure it's understood that in the landlord-tenant, these VRDs, short-term rentals, are not subject to landlord-tenant laws, and not subject to, there have been some claims that they're on fair housing standards, and whether or not those apply in this circumstance. They do not. And it's with this discussion we're having here. But there is a consistent norm and a guideline out there in the residential landlord-tenant area that looks at these kinds of issues. It talks about 2 persons per bedroom plus 1 as being sort of a guideline that has used. So I think we're well within what's being considered out here as an appropriate level. And so therefore I'm not changing the recommendation that's in there, although slightly I'm going to revise the language slightly just to take off one of the references that was in there. But you have had a lot of testimony on alternatives. So I've listed basically 4 different alternatives you could do here. You could go with the limitation as proposed, and that is the recommendation. You could do an alternative maximum limitation if you want. If you think that's too low, you could raise it. If you think it's too high, you can lower it. That's obviously something we can discuss. You could do flexible standards. One of the things that people have noted is that certain of the properties possibly could accommodate more based on their own characteristics. And so one of the things I talked about is a flexible standard that would allow, for instance, an area that has more sleeping areas than 5 to provide more off-street parking commensurate with the level there. So we currently provide off-street parking. I think the requirement, if I remember right, is one per bedroom plus one. And so if you had 8 bedrooms in there, you could say, you could have a maximum capacity, increase the maximum capacity on something like that, but they would have to provide 9 off-street parking spaces. That alleviates some of the concerns that have been expressed about parking and the issues there. And I guess you could combine a flexible standard if you wanted to do that with the requirement that it only be allowed for existing VRDs. All future VRDs will have to comport with the requirements of the code here. And you could work it in a grandfathering way that we would actually deal with that. You'd have to come in and make your application to be grandfathered with a flexible standard here at the first time that the first annual licensing that we do this year. The other option would be something that just grandfathers. You simply just say that if there's someone in existence at this time, on the time that the ordinance becomes effective and when first licenses are issued, you can set a maximum occupancy based on the individual circumstances for those particular grandfathered VRDs. And I guess the way I would deal with that is if they do not come in and basically perfect their grandfathered status, then they would not get that in the future. So they would have to get that at the first licensing and have to come in and do that to get that. So there's a couple of other options that we could consider. I think if you're going to go with something other than our recommended option, we want probably a little bit more time to work on what that might look like and how it might word. But that's at least something you can consider. And then finally, there's a variety of miscellaneous changes within the code. We've kind of taken some areas out that weren't flowing correctly and made those work right. We wanted to turn around I thought the time frame in which we issued the licenses was too long. I think we can issue them within 30 days after we receive the completed application, which is not just the application form, but they have the certifications that they're in compliance with our tax requirements. They provided us the notice information, all that different stuff. I think we can probably issue that in a shorter period of time. The notices themselves, there was a lot of comments about, we require them to post a notice on the VRD dwelling, but some people noted that the dwellings may be set back. You may not be able to see the notice that provides the contact information from the street. So we want to make sure that that is visible to anybody who needs to get that information if there's, and they want to, call the contact person to do that. So we're actually saying that it has to be visible from the street. So that could be on the house if it's visible from the street, but if it's not, they're going to have to post a lawn sign or something that would provide that information being visible from the street. And also then, in addition to providing the notice of all the rules, we've got the operating standards here to each of the renters as part of their rental package. They're going to have to post that in a prominent location inside the dwelling. That needs to be also there, that everyone who walks in will know that these are the requirements that are set by the license. The other part of this, I think, that we want to do is the effective date. And that, we talked about at one point being 90 days. It depends on when we actually do the date that we adopt the ordinance to set the effective date. But some of the issues that have come up are the commitments that certain property owners have made already through the season, and you could set an effective date separate than what was proposed before. I suggested you might want to do January 2nd of 2017 as an alternative. That would allow for the remainder of the summer season coming up, the fall season, and the holiday season next year to actually to allow operation and make it effective on a calendar year basis. You could choose some other date if you wanted to do that. The main thing is it has to be at least 30 days out from the date that we adopt the ordinance. So the final consideration was the fee structure, and as I indicated, I'm suggesting that we do the notices. That'll be additional work for our staff to do that kind of activity. So in further examination of the fees, we're recommending that you actually have to set the initial fee at $250 for initial one, $125 for the renewal. And then because we're also going to have, there's a requirement that the property owner, if they change the local contact, they have to provide us with that information immediately, and then we send out a new notice with that there'd be a $75 charge for any change in the local contact information. And we'd incorporate those fees into a board order and go forward. So that's what I have to present to you. You have any questions?
Commissioners? If not, let's move into the public comment, and we do have 12 people signed up. Mr. Miller, are you ready with your timer. And we do want everybody to have an opportunity to have their say, but we do have a lot of people signed up, so we will be enforcing our 5-minute time limit. Mr. Miller will signal me, and I'll hold up a finger when you've got 30 seconds left in your 5 minutes, and then indicate when we've reached time. So let's get started. Bill Tenpas. And then as signed up right behind him, is it Peter Leor?
Yes.
Okay, so,
Thank you very much. Bill Tenpass, 6805 Neptune, Dunedin Beach. We want to thank you, first of all, for your work on this process. It's been a long process. One of my comments will be on the extending the date, the effective date. It's already been 2 years. So it's been long enough. The local contact, we would like a local contact. We believe that's important. If somebody is a contact in Seattle and they're on vacation, there is no contact. So we need somebody local that they can reach immediately. Contact information. We think the county should notify and raise the fees accordingly, and we also would request that you have an electronic version so that we have the ability, if we are outside the 250-foot limit, we can get online and find out who the contact person is if those people are causing difficulty. The people outside the 250-foot limit, the problem with that is that they deal with the traffic, they deal with the litter and the dogs and the noise and the fireworks. But if they're not notified, they just have to have a way to get that contact information. Response time. We think that might be a little vague. We understand and appreciate the 1 hour issue. The problem is the circumstances are determined by the person that is renting the dwelling, and that is left up to interpretation, and that's of a little concern to us because they may decide that it is not something that is important at this time and may not notify. Garbage services, we think you've done a fine job, and we think the franchise helps, and that is important. It still takes care of the garbage issues. Occupancy limits. We like the limits that are proposed and the norm that's out there. And the reason for that is if there are different proposals or different rules, it adds to confusion. The second thing it does is that it unwittingly shifts the larger groups to the unincorporated areas. And those are the groups we're having problems with, the larger groups. We don't believe there should be higher caps. We don't believe in grandfathering because what you're grandfathering is the ones that are the problems right now. And those are the concerns we have. And so those are on the occupancy limits. We also believe on the miscellaneous changes, the effective date. As I said, we've been dealing with this for a long time. If you move into a city and you realize there's people around you, that's one thing. But what's happened is people have been in these neighborhoods and suddenly these large dwellings have been built into these neighborhoods and suddenly it has changed the livability and quality of life in those areas. So we didn't move there thinking this was going to happen. We lived there and then this happened. So it's been a difficult thing for us. By extending the time, you're extending the time at the busiest and worst times. Summer, fall, and holidays. Those are the times where we have the most problems. It's not during the winter. And so we recommend that. We recommend the 30-day adoption. We believe that's important. It gives notice. We've had 2 years. Notice 30 days, I think, gives adequate time. Fees. We think the fees are appropriate unless we grandfather or allow larger groups. Because right now, the people that have 2 bedrooms, and we're getting back to sleeping areas versus bedrooms, they can put a pull-out couch in the living room and call that a sleeping area. But if you define it to bedrooms and they have 2 bedrooms, that's appropriate. But if you're going up to 8 bedrooms and 2 per bedroom and then 2 more, that's 18 people. And then maybe they should pay more in fees because they're the ones causing the traffic and the garbage issues and the noise issues and the problems there. Again, I want to thank you for your work on this. I realize it's been difficult and new ordinances are always tough. We want to work with you on this. We believe that this is necessary for livability and quality of life. in the areas that are unincorporated and need your help. Thank you very much.
Thank you. Question for Mr. Belmont. Again, the adoption of an ordinance, the 90-day timeframe is...
I think we need to do that in order to make sure, first we get the notice out to the DRD owners that this ordinance is going to be in effect, that we make sure we have all the necessary application forms and everything developed. You know, we have to gear up our staffing with the sheriff's office to do that. So at minimum, I would say we need the 90 days. It's just, I think the other considerations are, you know, when you want to make it
Yeah,
effective.
and again, beyond that though, I mean, an ordinance takes effect 90 days from adoption unless we do an emergency clause, correct?
No, we can do it, we can do it in 30
We
days.
can do it in 30, but so that is a possibility. Alrighty.
Peter.
Yes,
Morning, Chair,
morning.
Commissioners.
thank you.
I've already spoke at length the last public meeting. I just want to touch on the occupancy limits, and I appreciate there's a couple other considerations you have to look over. You know, and the last speaker, I'm sorry, he's had problems with vacation rental near him, but for an operator who's been doing this for 7 years, it really is the vacation rental management company that needs to make sure that those problems are not occurring, and if they are, that they are responding to them quickly and adequately and resolving them. You know, there are several larger properties in unincorporated Lincoln County that have been operating as vacation rentals for some time. I can only speak for my owner, who invested a significant amount of money to upgrade the property and all of its facilities, and has played by the rules that have not been in place. And we have a really good record of, you know, being aware of what's going on at our properties. So I would just ask, as, you know, just a common businessman, that you would consider options C or D under the occupancy limits. There are unique properties. I've been on other sites and VRBO, and you'll see these properties that may not be following the simple rules that you're proposing. But there are people like Ocean Odyssey who have a history, a 25-year history, of making sure the guests are taken care of, protected, and the owners and the neighbors of those properties always know who we are, how to reach us. So I appeal to you on that line. I don't have any issue with any other proposal. They're all very reasonable, and like, for instance, Yahat's has very similar parts of their ordinance as well. So,
Thank you.
thank you.
Okay. John Hegel and then Fran Furter after.
I'm John Hegel. I'm from 6765 Neptune in Glen Eden Beach. I want to thank the commissioners for all your hard work, and I will not take extra time just to reiterate what Mr. Tenpass has articulated, and to also emphasize that I believe that we should stick with the limitation as proposed under occupancy limits. I appreciate your work. Thank you very much.
Thank you. Fran Furter and then James Nordell.
Good morning. I'm Fran Furter, Neptune Avenue in Glen Eden Beach, and I too want to reiterate my thanks for all the hard work that you've put into this. I appreciate it very much. I won't also repeat what Mr. Tenpass or Mr. Hegel have said. I agree with both of them. I want to address the grandfather issue just very briefly. I think, as I understand a grandfather clause, and I know the history of it goes back to the Jim Crow laws, but for our purposes in state government, grandfathering usually means that you allow a person to not follow literally a new rule because they've met the qualifications of that rule in some other way. I would like us to stick with that understanding of grandfathering, that we would only grandfather a dwelling in or excuse it from new rules if it has already met those rules in some other way. If it doesn't meet them in other ways, for example, if it can't provide off-street parking for the number of sleeping spaces that it wants, then I would oppose grandfathering such a dwelling in. Thank you very much.
Thank you. James Nordell, and then Annie Underwood.
Commissioners, my name's James Nordell. I like what you've done with the decision points, with one exception, and that would be the occupancy limits. The information that's missing in this summary is, although Lincoln City does have occupancy limits, it does exempt houses built prior to 2010. And so they have a 5-bedroom standard, but occupancy is not restricted on any house built before 2010. Okay. You also left out Newport acknowledges a prior use exception. Okay? And what's not in here also is Yachats, and not necessary that it be there, but it too has occupancy limits, but also it too acknowledges a prior use exception. So that's the part that's really missing here, and these other municipalities have recognized that there is, I think, a reasonable solution in terms of setting VRD limits and standards, but also recognizing that there are land use rights or land ownership rights that should be recognized as well. So I'm in favor of not the recommended opinion without at least in part putting in parts of C and or D. Otherwise, I think you guys did a great job with this.
Thank you.
Thank you very much. Oh, one other thing,
Yes.
I want to make sure this is in the public record. Letter from David Nepom, dated June 17th.
It is.
Okay.
Thank you. Annie Underwood?
No, thank you.
Okay. Lisa Glenn? Okay. Chantel Carpenter?
No.
Okay. Dina Rudd?
I'll decline at this time. I'd like to offer comments via right in a written form. What is the deadline date for that?
The board will have to set that once to see if you want to be, for sure, I would get it in before next Wednesday, week before
Next Wednesday. Okay, thank you.
Carol Niebert?
Carol Nybert, 6715 Glen Avenue, Glen Eden Beach. I agree with most of the testimony. Wanted to correct one thing on the garbage. There's nothing in here that says the garbage should not be on the street. Currently, it's been left on the street for as long as it's been in existence, at least 2 years. It should be moved off the street. Also, wanted to clarify number of persons allowed in the dwelling. A person would include a baby, a child in that number. So a lot of people get
No, I
confused.
think I think the way we've crafted that, it's if you're under 2 years of age, that's not considered against the upper count. And that's
Well, it's-
pretty common.
It is common in other
Jurisdictions.
hotels,
Yeah.
timeshares, and so on that a baby is, otherwise they cram.
Well, in our case, the proposal would not count someone under 2 years of age. That's what's proposed.
And I agree with notification because, I don't know, I guess for blocks, you could have vacation rentals. There's no limit on the number of them. For example, right now, I am the closest resident, and I'm at the end of the block, so I'm well over 250 feet. And I guess that's the only additional thing that I would add. The parking is the big issue. Right now, they're sleeping in cars on the street in front of our property, just causing a lot of noise, slamming of doors, et cetera, et cetera. That's the only thing I have on my list under, I object to the grandfathering in. And of course, the notification is important. So that the garbage off the street would be one thing I would want to add. And as a clarification on the parking, whether or not they could double park, triple park, stack. Also, I think something that should come into play on issuing the licenses or renewing of it is the history of complaints. They do not follow the good neighbor rule. So it just causes the longtime residents a lot of problems. You know, people leave Portland, Seattle, wherever, and they forget their manners. So I would appreciate some consideration on history of complaints.
Well, Mr. Belmont, essentially that's built in if somebody has...
Renewal process or...
Through the renewal process or in extreme cases where we could reach a
That's
stage.
part of the enforcement mechanism.
Yeah.
One of the things we can do is not renew.
Right.
There's also a process, though, where if there is a complaint, it is reviewed and could be addressed independent of the renewal process.
Right.
Yes.
And are the other neighbors aware or made aware of the accumulation of complaints?
No.
Is that public knowledge?
I mean, it's public record, obviously, that would be a public record, anything we've done with that, but there's no notification. We don't notify every time there's a determination made on that, no.
So the number of persons is anyone above the age of 2? Is that how you classify it? Okay. And do we have a contact person as far as the police department, or is it just whomever they list as a contact person?
No, they have to provide the local contact person. The police department, that we will have, obviously we have a line that you can get through to
Okay, so you had
so that
mentioned,
information will be available.
you had mentioned in the past that there would be someone made available.
We're running this program through the sheriff's department.
Okay, thank you.
Okay, thanks very much. David Nepom?
Thank you, Mr. Chairman, Commissioners. David Nepom, I'm attorney in Portland representing the SAMs. I've submitted written materials, actually several times, and my co-counsel, Mr. Pellington, has also submitted materials. The biggest issues are the grandfathering issues and the occupancy limits with this ordinance. Out of fairness, the SAM's residence, for instance, built in the late 70s, has been taxed by the county as an 8-bedroom unit for years and years and years. And it's been used as a vacation rental dwelling. One thing that has not been mentioned is the ORS 215-130, which specifically applies to counties only and does not apply to cities. And that requires the county to recognize pre-existing use grandfather rights with regard to land use matters. I think the biggest difference that Mr. Belmont and I have is that I believe, and I think I'm supported by the law and case law, basically says that a land use ordinance is something that affects land use, is a land use ordinance and would be subject to the grandfather rights of that statute. And even if you call a ordinance, a business license ordinance, if it still has significant land use effects, and if you have a restriction on occupancy, or you impose a restriction saying that you are restricted on use because you don't have pre-existing off-street parking, that is a land use ordinance, even if you call it a business licensing ordinance. And I think arguing form over substance does not work when you're in court. And if you do not recognize grandfather rights, I think ORS 215-130 definitely applies, and definitely the grandfather rights with regard to the land use ordinance aspects of this statute, or this ordinance, would apply. And you're in a mess in terms of dispute as to whether or not, for instance, you have not adequately recognized pre-existing grandfather rights for land use, and whether or not you're dealing with the taking of property and a variety of other claims. I think that can be avoided by dealing with this occupancy limits in a reasonable way and recognizing grandfather rights. In particular, the maximum limit of occupancy should be based upon a substantive basis, as opposed to a set cap. Your alternative options C and D go some ways toward that. C does not, as written by Mr. Belmont, because it says that they would need to provide 9 off-street parking spaces. Your ordinance as written basically says if off-street parking does not exist for an existing use, that on-street parking can be used to accommodate that need. That's a reasonable standard. It's understood, acceptable, but to require new ordinance that specifically says the property has to provide off-street parking for its unit is a land use ordinance. It's a restriction, and it denies the pre-existing rights, and it is unfair because these property owners, and not just my client but other large homes in the county, purchased their properties, expended money on their property, paid taxes on their property based upon the understanding that it would be allowed to be used for a higher occupancy than is permitted under this ordinance. I have another dispute with Mr. Belmont. I don't see anywhere in the Fair Housing Act that it specifically says that the Fair Housing Act does not apply here.
30 seconds.
Okay. So in a nutshell, there's nothing in the building ordinance that that basically says that there's a 5 maximum for a single-family residence. That is an interpretation. It is not in the actual statute. And there are larger families. The county needs to provide for these larger families that want to come to Lincoln County and spend their money. And so the occupancy limits, as I've stated in my written materials, and the grandfather rights, as I've stated in my written materials, need to be recognized.
Thank you. Cynthia Seeger and then John Oxenhold. Cynthia Seeger. Hey, John Oxenhold.
Good morning.
Good morning.
John Oxenholt, Meredith Lodging and Beachfront Vacation Rentals. Our company has become the largest vacation rental management company on the Central Oregon coast, and right now we actually only manage properties really from Rhodes End to Depot Bay. And we have about 200 properties. Of those properties, we kind of have a disproportionate amount of what I would call large sleeper homes, homes that accommodate 16 or more individuals. And most of those are in the city of Lincoln City, and as you guys all know, they're kind of revisiting their ordinances, and we've been a part of that process. We also do have a handful in the Gleneen Beach, Lincoln Beach area, and we really haven't, you know, Aaron would know better than I am, but we don't get complaints on those homes. We just haven't seen or heard of any complaints. I'm very, very sympathetic. I've been a lifelong resident of Lincoln City and lived in Rhodes End for 15 years, which you know, has a lot of vacation rentals, and I've lived next door to vacation rental homes, both homes that we've managed and both homes that have been managed by other companies. And I mean, I really get it. If you get a loud, noisy group in there, whether it's 8 people or 20 people, you know, 20 people are louder than 8, and if you lose your sleep, you're really going to remember that, and it can become a nuisance. I also kind of have the philosophy that the only good news about a vacation rental home is if an unruly group slips in there, at least they're going to be gone at some point. Sometimes you get a permanent neighbor that's also a nuisance, and you can't get rid of them. But I'm very sympathetic. My philosophy is that a well-managed vacation rental is a real asset to the community, and I think that as this industry kind of grows, the key is the companies that really are willing to make the investment in having the local infrastructure, the local office, the 24/7 on-call numbers, the security. A lot of the neighbors in Rhodes End now really appreciate our company because we have security going by middle of the night. They feel actually that they're also more secure. They've gotten to know some of the neighbors. And that's really why we haven't managed properties in Newport. We are just getting ready to open up an office here, and we're going to make a heavy investment in the infrastructure. In the large sleeper homes, because that's really, I think, the bulk of what I've heard here today being discussed, and the bulk of the potential disagreements among folks here. It's kind of similar to my wife's philosophy, and she's a much smarter person than I am, but you know, everybody used to be very scared to make their homes pet friendly. They were scared the pets were going to destroy the home, and you know, kind of her philosophy was nobody wants to bring an unruly pet to the beach. And so actually what we find is our pet friendly homes, there's very little damage. On the large sleeper homes, I think the key is the upfront screening process, because certainly if you get the frat parties, and if it's just like anything goes, you don't check, you don't call the folks, you're going to get, you know, some potential parties. But at the same time, what we see in our clients in the large sleeper homes is we see the multi-generation families. We see the families coming back to us year after year after year, where it is literally 3 generations that actually want to stay under the same roof. They want to have their own separate bedrooms, their own separate bathrooms, separate amenities. And our large sleeper homes, there is a huge demand. There's not a lot of them out there, and there is a huge demand. They book up literally a year out. And so one of the things that, you know, I would ask is if you, I'd ask for you to really let these new ordinances have a chance to take effect before there's further occupancy limits. But if you are going to make any change you make, at least if you make it effective a year out, it allows companies like ours to not have to cancel existing reservations. And again, most reservations are not a year out. On the large sleeper homes, they just are, because oftentimes it's these groups of families that have to plan and coordinate ahead of time. Matter of fact, one of our rules on the large sleeper homes with our reservation team is that if you get a last minute booking, you need to be very, very careful with that, because usually it's those last minute bookings on the large sleeper homes that are the party groups and the ones that are a disturbance for everybody. So I'm really, you know, in favor of no changes. Second place would be, you know, grandfathering. It seems to me like it's hard to change somebody that's been operating under existing rules for a long time. That being said, Wayne Belmont is a very, very bright guy, so I'm not going to get in a debate with him, because 9 out of 10 times I'm going to lose that debate. So there may be a way to do that, but I'm an advocate, and I think we all also need to remember that it's the balance between residents, but also the impact on the local economy. These vacation rental homes bring a lot of visitors to the coast, and that's what pays for the local restaurants, the local amenities, the things that permanent residents want, and visitors alike. And I think that a well-managed vacation rental home can be a great asset, and a not properly managed vacation rental home, monthly rental home, commercial property, anything can be the opposite of an asset. So that's kind of my 2 cents worth, and I appreciate you guys listening to me.
Thank you, Mr. Oxenholt, and thank you to everybody who has offered input on this. That is the list of everyone who had signed.
Do I have a chance to rebut something he said?
No, I'm sorry, we're not going to have time for that because we need to get
I'd be happy to visit with you
deliberation
afterwards, though.
and further. So if there's somebody who didn't sign up, hasn't already been heard, yes?
I'd like to speak. I didn't sign up.
Okay.
Is that what you're asking?
Yeah, you can now, so if you'll state your name for the record and...
Commissioners, my name is Richard Pendergrass. I live in Lake Oswego, but I have an interest in a house on Neptune. And all this talk about grandfathering is absolutely unbelievable. I'm reading from notes that the commissioners came down to Glen Eden Beach November 22nd, 2014. And in there, they stated that, the commissioners stated that under the Uniform State Uniform Building Code 2010, the maximum occupancy is 16. I had a copy of it. I don't have it now. And I'm also going to quote from an ad I printed off the internet for the mega house on Neptune, and just a few words out of it. They're advertising sleeps 30 to 33 guests. So as of 2014, May 15th, they were knowingly in violation of the state building code. All this talk about grandfathering is absolutely ridiculous.
But Mr. Belmont, again, the state building code, that 2010 cap, that applies to places built after that date, am I correct?
Again, let's don't get into the particulars of this,
Right.
because actually
'Cause
we're in
that's-
some litigation right now concerning this very issue, so I'm not going to discuss that, and I
Okay.
advise the board not to discuss
So
that.
that's been my understanding previously from talking to our planning department and
Well,
others.
so let's just
again,
leave it at, this
okay.
obviously is an issue that we're going to be discussing with a variety of parties, and we'll probably get a determination by the court.
Okay.
Well, grandfather, not knowing about that litigation, I have no comment on that.
Sure.
But grandfathering these houses when they, in my opinion, have knowingly been in violation for years is absolutely ridiculous. Thank you very much.
Thank you. Anybody else who has not been heard? Okay, come on up, please.
Good morning. I'm Artis Skimmel, 340 Stevens Street, Glen Eden Beach.
Okay.
I am very much in favor of grandfathering and very much in favor, against grandfathering people in. I believe that the rules need to be applied to, and we do know that we change rules, so I think that we have an opportunity here to get rid of this mega situation. And grandfathering, it seems that people have added on to their homes, or like across the street from me, two people live there, and now it has become a vacation rental because they sold their house. And so now there are up to 18 people across the street from me instead of 2. And if we all lived by the rules, we probably wouldn't be here today and needing to have this discussion about having licensing and these new rules. And if a house was bought and not built after 2010, for instance, mine across the street, I think it was built before 2010, but it was bought after that to become a vacation rental home. And I have just learned from my neighbor that they suspect that there is a home at the end of their block that has become, one of the bedrooms has become an Airbnb. So maybe something needs to be put into the licensing to include homes that become Airbnbs. And sooner rather than later to implement this would be my preference instead of January. Thank you.
Anyone else who is...
One more
Okay, go
question.
ahead, yeah.
Who is it that we would write to if there was anything that we came to mind about?
You can direct it to the Board of Commissioners, but send it to Tanya Graham over here.
Okay, thank you.
You can find her information and the address online.
Okay, thank you.
There's a section on the website for that.
Right.
Once again, Cynthia George, Lincoln County. I don't know, you guys. I think this is really strange. I came down here in the early 70s. My father was a jazz musician and opened up Salishan Lodge back. He was the first band. We lived at Salishan. My friends, there was Holiday Hills Trailer Park in Glen Beach back then that was nothing but vacation rentals. I cannot imagine anybody trying to stop people from, number one, making a living, making us more prosperous. If you see Friday nights in this entire town, it is dead. There is nothing. Nobody's making any money. So it's really strange. And then you've got the issue with everybody who could come in and build these beautiful big homes and move into the area, and nobody's got any place to live anymore. There used to be rentals where you could rent a house for $350. They're now $800, $900. You can't even get a house for somebody who's retired that can afford it. So for those that have and they want to protect their neighborhood and all that stuff, I appreciate that. The people living in the cars, it may be a longtime resident that's got no place to stay. So please be a little bit more compassionate, be a little bit more understanding. And you know, things happen. Things happen. There's going to be nuisances in life, and we all have those, don't we? So, thank you.
Thank you. One last call for anybody who has not been heard on this topic. Okay, come on up, please.
Okay.
You'll find me. My name is Aaron Linfoot. I work with Beachfront Vacation Rentals and Meredith Lodging as well. I wanted to come up and talk just based on the demographic in the room. For this industry, I wouldn't be in this. I'm based out of Lincoln City, but this county for that matter, if it wasn't for the industry that I'm in. And I've got 80 plus staff that work with me that rent houses, own houses. I've got housekeepers that own houses, and buy a lot of groceries in this area. So I just wanted to delve back onto that. And the whole working economy, you know, we're entering new landscaping, a new society, so to speak, and hearing some of the Airbnb comments and things like that. There's a lot of new things that are affecting legislation. And I just want to say thank you for you guys. Going down this path is not an easy one. It's one that you might lose sleep over, hopefully not. But I appreciate the time and effort you guys have put in there. Rules can be good. You know, I'm surprised too, just kind of with the, not the lack of support, but I would have envisioned maybe more people come into this. So thank you for your time on this. You know, keep an open mind on some of these new horizons that are coming, and really delving back in not just the rules and the application of the rules, but the enforcement and the proper oversight and management of them, because what's been reiterated, you know, I'll reiterate what's already been said, but proper management can make a huge difference in the application and the whole process. Thanks.
Thank you. All right, we are at the point now of Board of Commissioners deliberation, and I think if we just go down the decision point items one by one, and if we can reach consensus or at least majority sentiment on these points, Mr. Belmont can come back to us next week with a final draft ordinance for first reading, if that's okay with everybody on the board. Okay. How about first, the local contact and whether we should require that it be a local contact. Again, it could be the property owner, it could be a rental management services company, a private security company. What's the feeling of the board on that?
I think you need a local contact.
I do too.
I think we heard that loud and clear.
Yes, we did. Okay, then contact of property owners when there's a change in contact information. And do we agree with the proposal to have the county handle that notification and then adjust the fee schedule accordingly?
I think a notification is pretty typical as far as planning department when there are issues there. I sense from Council Belmont's comments, this is something that the county could do.
Well, in a licensing program, this is not a land use ordinance, so make sure that's clear.
Understand that.
But yes.
Let me
In this case, it would
rephrase
be
my
the
statement.
sheriff's office
Yeah.
as part of their
Notification is a
licensing.
process that is not new for the county.
No, we can handle that.
So we can handle it. I think that makes sense.
Distance, though, is a problem.
Yeah, let me ask Mr. Belmont a question. Would it be practical in your eyes to essentially have online a listing of licensed vacation rentals and the contact points? So
I'll need to talk to the sheriff's office, but I think that's probably something we could do. I think
Yes.
that's something we could actually put together. We're going to have to do a little bit of work in putting together programs. We've already been looking at that to manage the licenses themselves, but I think we probably could do something in which we post notification of the contacts.
So that would take care of the question of whether it's 200, 250 or something.
So if it had an
larger.
issue, they'd be able to go and based on an address, they could say, what's the contact?
Does that mean that, I think she had a legitimate point, that if the nearest person is over 250 feet, I think you gotta put the
Can I
nearest person in there.
suggest? Yeah, can I suggest also though, that remember what we're doing is with the, part of this particular contact information that comes later in the miscellaneous is that they have to post on the site at a visible location the contact information. If I live down the street and there's a loud noise going in there, I'm gonna be able to go on the street and get that contact information. I won't have it at my fingertips, in my house necessarily, but there's a way that you can get that information. If you're having a problem, you can do that and make that call. So there's redundancy built into the system here in terms of having that contact information out there.
So are we comfortable with 250 feet for direct notification of property owners?
Yeah, I want 250 feet.
I'm okay with that.
Okay. Response time.
But we're saying also that if there is no property owner within 250 feet, the nearest property owner then should be notified.
Well, full-time resident, is there a way we can monitor that?
Well, no, and remember what we're going to do is we're picking out property owners. We have to go by the records that are available from the assessor's office. So if I'm, for instance, a long-term renter, I'm not going to get that notification because I don't have any way to get that information. There's
It'll
no way
go
to do
to
it.
the
So you
property
use the
owner.
assessment records.
Yeah,
and
it goes
that's
to the
very-
property owner.
Goes to the property owner
Yeah.
who has to work with, if they have long-term tenants there,
Right.
they're going to have to work with them to give them the information.
Okay, but item number 3 is the response time. The original draft, the current draft says 20 minutes. Staff recommendation is 1 hour. And just personally, I'm going to say I think that is a reasonable modification when you take into account time of day, time of year. Certainly I think we've all experienced it taking an hour sometimes in the summer during the daytime to get from Newport to Lincoln City or vice versa. And again, that's emphasizing that this is within 1 hour. It's not wait an hour and then go to respond, but that's the maximum. Feelings of my colleagues on that?
Well, again, I will ask Council Belmont, the language that says within reasonable period or within a timely manner, those are things that are like easily established or
We
standard
have
language to
standards,
some degree?
reasonable standards all through the code. It's not something we haven't dealt
So,
with.
yeah, it's not a new application.
So there was concern about vagueness in that, but if you add the 1 hour
If you have, you're
maximum
giving some,
response time to that,
we're going to use that as the default. Basically, you'll use that as the default, and unless circumstances require greater or lesser, you're going to look at that. It gives us some flexibility to deal with these issues.
I'm comfortable with the revised language.
okay. Garbage service, do we want to require franchised service?
I'm in favor of franchise service. I think that's just one of the things that Lincoln County does. We're in charge of these franchises. If they can't respond, then it's our problem over the franchise service, but I think for the benefit of the health and cleanliness of the whole county,
Well,
it's
as already-
appropriate.
Excuse me. As has already been pointed out, the 3 haulers within the county have a variety of ways that they can specialize or tailor the garbage service depending on the needs. So I'm in favor of that change.
Question for Mr. Belmont. Can or should we spell out explicitly that cans not be left in the street? That's one thing we kept hearing several times, that cans would be
My
left in
concern
the
with that,
street
I do
for
understand
days.
that, but if you're gonna do that, I think you need to do that for residents as well as VRDs.
Right.
That is an issue that's actually out there for everybody. You know, if we need to do that, we need to do it on a countywide basis with our franchise haulers. And I think it's a difficult, that would be a very difficult one to do.
With the automatic pickup trucks they have now, that can needs to be located near the street, and then trying to off to the corner. We have trouble where I live with the wind coming up the street, and if you, it is what it is, and everybody's doing it. We have to share the cleanup in that.
And might I suggest that this is obviously, we'll put out an ordinance, we'll do something, and we're gonna see what works, what doesn't work. And if all of a sudden we get all kinds of complaints about that being an issue, then that gives us an opportunity to look at that and see whether or not we want to, do something different in the future.
Well, long term, if we were to take those cans off the street, we'd increase the cost of garbage considerably, because that would require a man on the truck to go get it and put it onto the street. So, and for the cost, we know that some people have trouble with the cost of getting their garbage now. I think that we have to go with, like you say, completely across the county for everyone. You can't just do it.
That's not currently a requirement for residents.
Well, we don't have mandatory service, period. This is actually the first time we're imposing mandatory garbage service in any situation. And I think the scenario we heard at several of the community meetings is, unlike a fully owner-occupied residence that maybe somebody leaves a rental, they put the cans out in the street, they're picked up, and then if that rental isn't occupied for several days, then the cans just end up sitting in the street for several days. So
give me direction.
I'm comfortable with the proposed change.
Okay, then it sounds like we've got a consensus. We'll leave it at that for right now, and we'll monitor. I'm going to skip over occupancy limits because I suspect that's going to be our most challenging discussion, and go on to the miscellaneous changes. I think the big question within that is setting an effective date of January 2nd, 2017. We heard more than one speaker say we've been wrestling with this for more than 2 years, and why can't it be sooner, versus Mr. Belmont saying that staff needs some time to gear up and be ready to fully implement the program. Any thoughts on an effective date?
That seems kind of long to me. I think there ought to be something in between. It's a long time. But
I can go either way.
I'd like to see it quicker than that if we're going to do this.
If we're going to do it back to the original, which was 90 days, what I am going to do is try and plug in a specific number. So look at when you do a first reading, a second reading of the ordinance for adoption, and then run that 90 days out. Rather than say 90 days from the date of the ordinance, which is very common, you do some of these things. I'm going to have it date specific. So I'm going to try and make it the first of the month of a month, or the end of the month.
So if we did a first reading at next week's meeting, would the second reading be at the and adoption at the following week's meeting?
No, 2 weeks. You have to have
2 weeks out. That's what I thought.
So it'll be July 6th.
So we'd be talking about adoption July 6th, and then potentially, if.
So I think if I looked at it before, it would be an effective date of November 1.
Okay. If we go on this, so potentially that's what we're looking at then, if we go with that. So I think that's a consensus on that point.
Okay.
Are you okay with that, Commissioner?
Yes, November 1
November 1, 2016 effective date. And again, at the point of adoption, we'll start getting word out to folks to get licensed, as we discussed previously. And that'll be essentially their grace period to have their license in place by the November 1st, 2016 effective date.
Right.
And licenses issued in 2016 will be effective, we said previously, I just want to verify, through calendar 2017.
Well, and actually, I went back to that. We have, and I need to have a little discussion. That's one thing I need to come back and talk to the sheriff's office with. Is we actually said they're effective for 1 year, so we didn't necessarily say they're an annual license on a calendar basis. It's they're effective
1 year
for 1
from date
year.
of issue.
But I want to have some further discussion, a little bit of discussion with the sheriff's office if they would prefer to have this on an annual basis based on a calendar year basis. If that's the case, then what I'd like to propose we do is that we come back and we make the initial one that's issued on November 1 would actually be good for 14 months. We wouldn't make them come back in January.
That's what I was trying to say.
We can do that, but I need to have a little bit of discussion as I'm looking at this.
Get
I want
some further feedback from the
further
sheriff.
feedback from the
Okay.
sheriff's office.
Fees, $250 for the initial license, $125 for the annual renewal, $75 for a change in local contact information.
I'm acceptable with that.
Okay. That seems reasonable, and again, from what I know about what some other municipalities are charging. All righty. The elephant in the room, occupancy limits.
Best for last.
Yes. So Mr. Belmont has given us 4 options here. The 16-person limit as proposed, a different alternate, or flexible standards tied to off-street parking availability, or grandfathering existing units and imposing the cap on. Then I assume, Mr. Belmont, if we did go to grandfathering, that then the cap would apply to newly built or newly licensed VRBs.
Yes.
So I wish I knew the answer to this lawsuit that's out there.
Well, I'll just say
That's a
this
big
much. That's a difficult one, which we don't have the answer to that. And I'm not going to, I can't tell you with 100% confidence that this is going to be something that isn't. It's going to be challenged. I guarantee you that. Right. That's what we do know. I would note that there is just in terms of this argument that this is grandfathered or non-conforming under the land use code, this is not a land use ordinance, number one. Number two, as I indicated, and I'm not sure where my colleagues, if they have not seen the case, Lincoln City did changes in their business licensing program. They actually processed it as a land use procedure. They follow those procedures. There's elements of it that touch on elements in a zoning code. LUBA said that's not a land use decision. Very recent case that said that. So this has been, it's gone up in terms of the way we're approaching this thing. So I guess I respectfully disagree with my colleagues as to whether or not there's either grandfathering issues here that you're obligated to do that, or non-conforming issues, I should say, or that this ordinance, constitutes a land use ordinance. And I just disagree with that analysis. But obviously, we're going to end up litigating that issue, and we'll see where it goes. That's the best I can do for you.
Let me ask you this, Mr. Belmont. If we do adopt this limit and there is litigation and that's overturned, it wouldn't impact any of the other provisions of this
We have some
licensing program?
severability language in the code, and so what it would do is you could sever off the occupancy portion of that thing. That's what's challenged.
Okay.
You want me to go?
Okay.
Well, I'll start. I have sympathy for businesses that are in place. I've been suffered a couple of times, more than a couple of times in my life, by government changing the rules when new players come in. So I'm kind of leaning towards some form of grandfathering in these existing businesses. Now, I know it's not popular with some people, but I've been on the receiving end of it 2 times. Now, as to whether C or D it works, I haven't come to any conclusion on that, but I don't like to see businesses that have already been there. My reason is worried is that when the state laws came into existence, some of these businesses or the buildings were already there and were purchased. I believe probably a couple of them may have already been in business too. So it's going to be I think we're gonna do something, and we don't know for sure if we've really done it. That makes it even more complicated.
Well, I'm probably at the other end of that. I think regardless of the decision that we make, there will be some people that are happy and there will be some people that are unhappy. I look at what decision is made, who will it have the greatest impact on, and when we look at occupancy limits, there are a relatively few number of VRD units that have the potential to be impacted by whatever that number is established. I think when you look at the number of individuals in these different units, when you start talking about, I'll use the existing number 16 versus whatever another number might be, when you look at the total pool of VRD renters, that cap is going to affect that total pool very nominally. I also believe that a cap is not going to put anybody out of business. I didn't hear anybody come forward and say, if you put a cap on this, we'll go broke. I think that most of these units would have the ability to tolerate a, relatively speaking, nominal or small reduction in the maximum number of individuals. And so I'm not sure that 16 is the right number, but if you look at what's gone on in Lincoln City and Newport, again, there's some, I guess, different interpretations, but certainly based on the information that we've been provided by our county council, limitations in Lincoln City would be 11, Newport 12, we're looking at 16, so that's, 33% more than the city of Newport. So I'm inclined to look at some kind of a cap, whether it's 16 or 17 or 15. I'm open to some kind of discussion along that, but for the reasons I've already stated, I think it's reasonable to have some kind of cap.
Okay, I'd like to respond to that because being in business, you're right. If you look at the overall average, it isn't. But to the individuals that have invested their money, it could be if you have a large one. I would not want to see any more large ones built by any means, but those people who've already invested their money, it could be a very big attack to them. And like I say, I've been in this kind of businesses and watched things just go apart because of the average. These people are not the average. They're rare. Unfortunately, there's somebody does live next to them and may feel strongly about it, but that's where I'm at this point.
I understand. I think if we're going to address, livability and quality of life in neighborhoods, this occupancy limit is a factor. And it gives us another tool to be able to manage the complaints and the issues that arrive. Yes, I'll acknowledge that there are owners that have had no complaints, but as I've stated previously, those properties will change ownership at some point in time, and there's no guarantee that without some kind of a cap that we won't have problems in the future. But I also understand your comments. Unfortunately, as I said, there will be winners and there will be losers regardless of the decision we make, and I'm trying to make one that I think will have the least adverse impact on the fewest number of people.
Well, let's hear from Bill, because
Yes.
yes. Three of us.
The chair has been waiting. Yes, I don't usually talk about myself in third person. I've got to admit, this is the one that I have been turning over in my mind to the greatest extent, and I really do hear both sides. I go back to what really started us on the path of looking at this licensing program more than 2 years ago now, and it was impacts on quality of life in neighborhoods, and the vast majority of those complaints related to parking, noise, and garbage. And Neptune Avenue kind of became the poster child, or you could call it ground zero, for a lot of that discussion. The two large rentals at the end of the street, I believe at one point, the one overlooking the ocean was advertising that it slept 35, and the one across the street from it that it slept 24. And for anybody who hasn't been down Neptune, it is really a narrow street, no curbs, no sidewalks. We saw pictures on numerous occasions of traffic blockage due to multiple cars encroaching on what was the apparent right-of-way. And I remember thinking, let's just hope there's never a large fire or a medical emergency or something like that. And I said nobody would have ever allowed a 60-unit motel at the end of a narrow dead-end street like that. On the other hand, I do have concern about folks who established these rentals under what they believed were the legal standards at the time, and have been operating under existing law. We haven't had a licensing program up to now, and so I guess I'm leaning towards the 16-unit cap, or possibly option C, where we would offer those folks who can provide adequate off-street parking an opportunity for grandfathering.
I guess I'd ask a question on that. When you were going through these points, Council Belmont, I made a note. The document states that a maximum 25 persons property would need to provide 9 off-street parking spaces. How's that ratio determined, or?
That's the parking we have currently. For new ones, I think don't have the actual ordinance, but I want to make sure I got that right. It's 1 parking space for each bedroom or sleeping area, plus 1. I think is the way that works.
So, question related to that, and I think this came from the audience, that is there an inconsistency in the standard if we say existing rentals can utilize on-street parking, but we say for somebody above the 16 cap, we're requiring them to provide
No, what you're doing
off-street
is you're
parking?
actually providing a grandfather. I mean, if you're using C, what you're doing is providing a policy choice that would allow some grandfathering, but under these limitations with these flexibles. So it would be a higher amount you could get there, but you'd have to deal with that impact on parking by providing the off-street parking.
This is 2 people win. Won't be the first time I've lost a vote around here.
I might be the loser.
I'm sensing 3 different points of view right now on this issue. How do we get to the middle?
You may not have to. You may have to just vote, Bill.
Yeah, I'll vote. Well, if I was to cast a vote right now, I'd cast a vote for C. Commissioner Hunt, would you be comfortable with C, or are you going to hold for A?
I'll vote against it, but that's all right. Got
Okay.
2 votes.
Are you comfortable with C, Commissioner Thompson? Which is the limited grandfathering if they can provide adequate off-street parking.
In reasonable compromise, I'll go there.
Okay. So I believe, Mr. Belmont, you said you might need a little more time.
Yeah, I might need a little
if we
more
went
time to
that.
work that language up.
So
Yeah, but when the vote comes back to me, I may change my mind when I see how
You have to make your decision on the
Yes.
ordinance.
But let's see what you can come up with
All
to
right,
expand that.
that gives me some direction.
The
in terms of
language
what
in
to
that,
do.
it cites one specific instance, I guess. If I think about it, you're saying that there would be, based on the number of bedrooms, and how's that determined?
That's in the application. They come through and talk about the sleeping areas. They'll have to identify what those are in the licensing process.
Okay, and how, well, and maybe this is a conversation for the next time we discuss this, but how is off-street parking defined?
I'll have to look at the code, but basically it's what it says, off-street. And it can't violate any other zoning or.
That gives them an option.
So, yeah, this would give us some option.
I'll look forward to.
And I
seeing
think
what-
that with your permission, since we've been approached by several of the larger VRD owners, and there are some representatives of others, I'd like to have that conversation with them and look at specific properties to see how that might impact those specific properties. Because I think it'd be good for you to know, does this alleviate some of the concerns with grandfathering from their perspective if we do something like this, or what does it do? So I'll get back to you with that.
So when What's reasonable on the court case? Any idea when we might get a decision?
Well, there's different court cases. There's a different issue right now that deals with a building code interpretation. That's the one that's currently at issue. But in my opinion, that doesn't impact the final decision you make on this. It's if somebody's going to do it, they're going to challenge the ordinance after it's adopted.
Then I have another question.
And I can't tell you
I do
that.
too. Go ahead, Commissioner.
When you talk about flexible standards, the maximum of 25 that's cited in our document is based on 8 bedrooms. So if somebody had 12 bedrooms, that maximum would be significantly
Yes.
higher.
Yeah, so basically what you do is you grandfather and you'd look at the number of sleeping areas that they have in existence, and you'd use the formula we've got for a maximum for these grandfathered ones. That's 3 per sleeping area plus 1.
So that's-
Just have a maximum, then you come back and say you'd have to have that additional off-street parking to offset.
Right.
That's how that would work.
Let's address another point that came up, that assuming not all of the homes with a capacity greater than 16 can meet this standard, there was some request, given that a lot of these places are booked out a year or more in advance, that we have a delayed effective date for that cap to take effect. And I propose that if we say the ordinance is effective November 1st, 2016, that cap goes into effect November 1st, 2017.
I agree.
So for the places that are booked already for 2017.
They're already booked.
And again, I'll remind everybody that we will have a dedicated enforcement officer here on for the very first time. So if there are problems at these homes or any of the homes, there will be a response available. I think a much more timely and effective response than we have right now.
And I think that you also have this court case hanging out there, and maybe more court cases coming, that may turn around and say, these are already in existence.
Yeah, if the courts say we can't have this limit, then we can't have it, but at least this gives us an opportunity.
I might propose a little different thought. Rather than November 1st of 2017, I mean, we're talking about making these changes now. A compromise position might be June 1st. I mean, that's a year away, or July 1st is a year away. So I'll just throw that out.
Can I suggest again, let me have a little discussion, and I have to talk to the Sheriff's Office again if we're going to do a calendar year basis for these things. I'd actually run it to December 31st.
Of 2017, if we were to.
Or to whatever date it is.
Whatever, okay.
Yeah.
All right, so you'll come back to us next week.
But I hear what you're saying, you want to
An
talk
updated
about
draft
that
then.
too. Yes.
All righty, thank you, Mr. Belmont. We don't have any business today as the Board of Commissioners is governing body of countywide service districts. So we move on to reports from commissioners.
I'll pass.
I'll pass too. And at this point, we now have constituent input on any topic not on the agenda, up to 5 minutes.
Good morning, commissioners.
Good morning again, Ms. George.
Yeah. So this is kind of ironic that we have this meeting today and the grandfathering issues. I know a lot of these people aren't really aware of who I am, so I am going to introduce myself as the owner-operator of Going Green West, a medical dispensary out in Toledo. And we've been in existence there for almost 3 years, and the county has decided to bring a lawsuit against us for serving sick people on a nuisance charge. And so this is kind of ironic. Like I said, I brought up the budget issues on the legal counsel, and one of the things I know that you've hired a new legal counsel here just recently. And I'm very, very curious, and I know you're not going to respond, but hopefully somehow we'll find out on this budget for legal counsel, because you, I assume this is Mr. Belmont's $109,000 a year on his fees or his pay. And then you went to, here, let me get this. You went from $88,000 $100,000 to $192,000 in the 2 years for assistant counsel. And I'm wondering if that is included the new counsel that you hired this year, or if that's an additional, so there's more to that legal counsel fee. So that's something that I'm very curious about, because I find it kind of ironic that the county is paying almost $300,000 in legal counsel, and I can see why, because obviously we like to violate people's rights, to turn around and hire an outside law firm to come after a nuisance in Lincoln County. I think that's really bizarre that you would spend that kind of fees, and you think this county has that kind of money to spend, and then turn around and hire additional legal counsel. So I was hoping that the newspaper would put that out, and Newport News Times hasn't said a word. I'm happy to let you all know that in the last week, we've already gained 185 signatures on a petition of support for our dispensary. So that was really nice, and I expect if we go put it out publicly, we'll get a lot more. We plan on doing a media campaign as soon as our lawyer responds to the county's summons. And so this will be all over the place. So like I said, I really appreciated the grandfathering issue here today. That's been very appreciated. So I just thought I would just follow up. The other thing is, I was wondering if there was any actual veterans on this commission. And I know you don't talk to me and you don't say anything, and yet I've watched the RV or these vacation rentals. I've watched those meetings, and when people came up and you guys just sat and visited and talked, and for 3 years you refused to say anything to us. And so I don't know how we'll find that out either, but I noticed that I was reading that Commissioner Hall, you've put in to become the national vet rep for the counties.
No, that's not correct. I'm on the National Association of County Veterans Affairs Committee.
Okay, and you have not nominated yourself for a position?
Yes.
Okay, well that's, and so are you a veteran?
No.
Okay. I'm glad that we got that out. I'm sure that the veterans of Lincoln County appreciate to know that fact. I don't know why someone like John, who's actually a veteran and who does actually work for the veterans in Lincoln County, is not somebody that would be considered.
This is a committee of elected officials.
Yeah, well, maybe we all need to change that. So, again, the fees that are paid out, I don't understand this Oregon Cascade West either, the COG of another $20,000. Are these just fees that are paid out to belong to a group? Like the Association of Oregon Counties? I mean, you know, that's awful lot of money that you're throwing around for memberships. So anyway, I thank you. I do want to say one other thing. I appreciate the fact that we've got new doctors in the emergency room here at the hospital. I was taken in Monday. I've got a kidney stone, and for a year I've been ignored. Never got any diagnosis, and I had classic symptoms all the way from last year. Got new doctors, new nurses. Boy, they took me right in and found the problem. So you did something right. Thank you. Have a wonderful afternoon, Commissioners.
Thank you.
We do have an executive session, Commissioner.
Okay, is there any more constituent input? Then at this point, we will, Mr. Oxenhall.
I'd just like to thank you guys all for everything you do. I don't necessarily 100% agree with the decision today, but I do know 3 out of 4 of you guys up there, and I know you guys always try to do the right thing and have a very, very tough balancing act many, many times. So really respect everybody up there, and you know, Wayne has a tough job. Terry's been doing a tough job for a very, very long time. Bill, you know, whether it's been on the radio or here. So you guys have all served this community a long time. Appreciate it. Just want to say that. And also wanted to say that it's very nice when folks from opposite perspectives, like the gentleman in the red shirt and I, can actually agree on a lot of things. So it's thank you for your time.
Thank you, Mr. Oxenholm.
Appreciate it.
Do we anticipate public action following the executive sessions?
No.
Okay, then we're going to recess the public meeting. We will reconvene momentarily under...
How come he got a chance to talk and I didn't get a chance the second time?
It was under public comment.
There's open public comment on items that are not on the agenda, and if you did want to address something not on the agenda,
What was he addressing?
I was just trying to thank them for their service in general.
if you'd like to come forward, you can come on
I
up.
don't know what I'm going to say would be proper or not. But one thing I...
You can say anything you want, believe it or not, under this.
Well, when I first bought my house in Glen Eden Beach, I did a lot of research to make sure there were no vacation rentals. And then all of a sudden, they're allowed, and now you're even going to allow more grandfathering. What about my grandfather rights to purchase a home in a strictly residential area with not even supposedly duplexes allowed? And now you're giving all these grandfather whatever to anybody who has an attorney, probably. And so I would like my rights to be considered on not having all this grandfather stuff in there. I bought a home, and I invested a lot of money, time, and effort into making it nice, and then to have other people come in and wreck it.
Okay, thank you.
Thank you.
Yes.
I'm Bill Tempest again. I'd like to appreciate the session. As was said before, I don't agree with some of the decisions that were made. I also would ask Mr. Belmont, if you're going to meet with the management people to find out how that affects them, I would like you to also meet with us to find out how it affects us.
I'd be taking the input.
Okay, and I would hope that would happen. The second thing is, I would like to say that this is a thorny issue that's only going to get worse. It's not going to get better. And unless we have some standards now, it's going to continue to grow. And I appreciate you attacking this, and I appreciate you taking some stands, and I thank you for that.
Thank you.
And one other thing. We have more in agreement with the management companies than disagreements with them.
Right.
If they were well managed, like the gentleman that was just here, and managed the properties appropriately, we would have no problem with that. The problem is the people that don't have management companies and rent to anybody and as many people as they possibly can. And that's where the problem lies, not with the management companies. And I don't want that divisive thing to think that we are upset about management companies, because we are not. Thank you. Thank
Probably
you.
the 80-20 rule.
Thank you very much.
Yes. Yes, sir.
So when Yahats was going through this whole process, we would keep coming back to it, 6 months, a year later. And every single time it was the same argument. And it came down to management companies not following the simple rules that were in place. And so at one of the meetings, I just looked at the council and I said, why are we still talking about the same management companies that are not following the simple rules? If I lived where they lived, this is not a problem of occupancy. It's a problem of proper management. They should not have to deal with this. I personally have an Ocean View home surrounded by vacation rentals. And believe me, if any one of those I was having problems with, and I went to the management company and they did not take care of the problem immediately, you would be hearing from me. So it's not an occupancy problem, it's a management problem. I feel for you, I really do. If I managed those homes, there would not be a problem.
Well, that may be true, but there should be some sort of a limit.
Yeah, I just don't think that's the problem.
Some people don't follow the law.
Okay, okay, folks, we really need to move the meeting along.
We
I'm
got-
sorry, and we don't.
Right.
No.
I
So,
just-
thank you.
I know, but there, when I take a phone call for a
Mhm.
prospective reservation, one of the top 3 questions I ask, how many vehicles are going to be on that property?
Great.
Second question, maximum number of occupants.
Mhm.
Some people do this right. A lot of us do it right.
Like I said, the 80-20 rule, I really believe is a.
But I don't want to be I don't want my owner penalized because of those 20.
Well,
That's-
unfortunately, that's, I think, the way it works with a lot of laws and regulations in this world.
I think there's still, room for fairness.
Well, that's what we're trying
Thank you.
for. Thank you. Okay, at this point, we are going to recess the meeting, and I'll mention that we will not be in session here next week. Next public meeting of the Board of Commissioners will be at 5 p.m. Wednesday, June 29th, a joint session with the Lincoln City Council at Lincoln City Hall, with the Board of Commissioners meeting following at 6 p.m. Right now, we're going to recess into executive session pursuant to ORS 192.6602E to discuss real property transactions, and ORS 192.6602D to discuss labor negotiations. We're in recess.